have anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. My name is Vicki Henry. My pronouns are she, her, and I'm your panel chief for today. Welcome to the September 15, 2025 sitting of the Appeals Court. We're starting this morning with a panel that will then take a recess, and we'll have a different panel for the rest of the cases. I'm delighted to be joined on my right by Judge Hand and on my left by Judge Tan. You are welcome to share your or your client's pronouns or not as you see fit. We have 15 minutes per side for argument here in the appeals court. For better or for worse, we do not have rebuttal. Every time I tell you, and we all tell you, every case, actually, every panel, that we've read your materials thoroughly. It seems like y'all don't believe us, but we have. And we have them on our iPads, so if you see us glancing over it, that's what we're doing, looking at your materials. So I'd encourage you to jump to the heart of your legal argument, but you can start where you wish because it is your time. And we often ask a lot of questions. I'd encourage you to think of that as a good thing because it means we are interested in your case and we are trying to get to the heart of the legal issues. With that, I'll call the first case, which is 2024 P1075, Commonwealth versus ORTEGA.
Good morning, Your Honors. May it please the Court. Attorney Andrew Power for Defendant Jose ORTEGA.
Sure, and I do want to say this case is partially impounded. I assume it's for victim names.
Yes, okay. Understood, Your Honor.
Great.
So going to the first issue, the admission of bad act evidence without a limiting instruction created a substantial risk of miscarriage of justice for 4 reasons. First, there was error. The judge failed to give a necessary and requested limiting instruction on the other bad act evidence. Second, the error was prejudicial because the jury were free to conclude that my client had a propensity to abuse young males and therefore must have abused the alleged victim. Third, the error materially influenced the verdict because the bad act testimony overwhelmed the testimony of the charged conduct. And fourth, counsel's failure to insist on a limiting instruction was not a strategic decision because that instruction would have only benefited the defense. His decision to allow the bad act evidence in without objection was a strategic decision. However, his failure to request the instruction that was requested and set out by the judge was not a strategic decision. That was a major strategic error.
Was that included as a basis for the motion for new trial?
The failure to...
Was there an ineffective assistance claim based on the failure to request the limiting instruction or to remind the judge about the limiting instruction?
That was the entirety of the motion for new trial. No, this is a Randolph claim. This is not a claim of ineffective assistance of counsel.
Right, but could that have been raised, and if it could have, why wasn't it?
It was waived at trial, so it's considered on direct appeal under the standard for waived claims, the Randolph standard, which does not apply to the ineffective assistance claim. Ineffective assistance claims are not brought under the Randolph standard. If the Randolph standard is met, if all 4 points are answered affirmatively, then ineffective assistance is presumed.
Thank you.
So can I ask you, the whole defense at trial was that the victim was lying, fabricating the incident, including the bad acts evidence that came into evidence at trial, correct?
That's correct.
And so how do you respond to, and I believe the Commonwealth raises this in their brief, albeit in a footnote, on page 27, the footnote 23, in which they, you're probably aware, they say that a limiting instruction would have made little sense and not advance the defendant's cause, right, the defense, and that was enough for the defense that the victim said the other boys were there, and the other witnesses stated that they were not, because I believe the defense counsel at trial did not object, and in fact, he told the judge, I think it was at a pretrial hearing conference, right, that his investigator, they had located and spoken to the witnesses, and they expected that they would come in and deny the prior bad acts, and in fact, that was much of his defense, correct?
That's correct, yes.
So how would you respond to the Commonwealth's.
Okay, let me begin with the trial counsel's strategy, the background for trial counsel's strategy. So the Commonwealth moved in limine to admit RM, I'll refer to him as RM, RM's testimony about 8 alleged sexual assaults. So in his first complaint, RM alleged that he could name a dozen young fellows who had also been abused by my client. When it came down to it, the Commonwealth named 8 individuals, RM, EJ, JC, JM, NZ, RZ, WG, and Short Guy. Now, those allegations were investigated both by the Commonwealth and by prior counsel, by trial counsel. None were corroborated, so the alleged victim, RM, was the only person making these claims. Trial counsel was able to locate 3 out of those 7 individuals. I, independently, using counsel's investigator, was able to locate 1 additional individual, and we also found materials, a Commonwealth interview with another individual, EJ, who said nothing happened. So counsel, it was a reasonable strategy. However, it only applied to those people that he brought before into court, that he brought in to testify, to JM and JC. Now, they came and they denied that anything happened. So it was still up to the jury to believe whether or not JM, JC were telling the truth or whether RM was telling the truth. If they concluded, and there was a real risk that they might conclude that RM was telling the truth, and if they concluded that RM was telling the truth, then without an instruction, this evidence, which was really toxic, this bad act evidence, would be used for its full probative value on the issue of my client's propensity to commit the crimes. Now, the judge himself said that the testimony was not admissible to show propensity to commit the charged crimes. He said it was not admissible for a bad character. So counsel's strategy, while justifiable, I guess, within the realm of trial strategy on the point of contradicting, impeaching RM with the testimony of the 2 people that came in to testify, still, there's no reason for him not to request that limiting instruction because it's prejudicial. The jury would consider my client to be of bad character and having a propensity to abuse young males.
But, counsel, I guess the concern that I have is that something you just said, which is if the jury believed RM, then ... The point is, but if the jury believed RM, they didn't need the other evidence for propensity. They just believed RM, and then the Commonwealth sustained its burden of proof on the charges.
But they could believe some of it, not all of it. They could believe some of the allegations. They could simply look at the weight of the allegations and believe RM based on that, saying, well, look at all these instances of abuse, literally hundreds of instances of abuse. There are 6 charges, but he committed all this other abuse. He's an abuser. He's being tried as a serial abuser. The charges must be true. So that weighs, that'll go towards their credibility determination. It's not like the credibility determination comes before they consider this other evidence. The bad acts goes into the credibility determination. When they're weighing credibility, they may also weigh the fact that, well, he seems to have a propensity to abuse young male Hispanic baseball players, so RM is probably telling the truth. Also, the Commonwealth argued in its closing, why would RM lie? Why would he name all of these other people if they could come in and prove him wrong? So the Commonwealth argued that they were lying. JC and JM were lying, not RM. So I think a whole bunch of different factors came in to evaluating RM's credibility. And the issue of the use of that testimony as propensity evidence or bad character evidence was a separate issue that went into evaluating the credibility.
Attorney Power, reading your reply brief, I wasn't clear on whether you were pressing the argument that I understood you to be making in your primary brief that the bad acts evidence shouldn't have come in at all, and the argument that limiting instruction was required. Are you focusing only on the absence of the limiting instruction, or are you also challenging the admissibility of the bad acts?
I'm challenging the admissibility of the bad acts without the limiting instruction. So the bad act evidence that came in was overwhelming, and the limiting instruction was even more necessary because of the sheer volume of bad acts testified to by RM. So I began with a broad argument in my brief,
Right.
and then responding to the Commonwealth's brief, I really narrowed it down to the limiting instruction, which was the very clear error that was promised by the judge, requested by the Commonwealth, very important, essential, I think, under our case law, but not given.
That's what my impression was, and I wasn't sure if you were taking the position that had a limiting instruction been given, the bad acts evidence would have been admissible, but that it was not proper to admit it without the limiting instruction as an alternative, more narrow argument than the broader one you made in the primary brief.
Right. Well, my problem here is that the judge found the bad act evidence to be admissible for certain purposes, those very limited purposes, course of conduct, context of the abuse. Counsel did not object, so we're in substantial risk of miscarriage of justice. So if he had objected to the bad act evidence coming in, I would be arguing that issue.
But you're not arguing that had it been that simply the admission of that evidence with the plan to provide a limiting instruction created the substantial risk, as you say in your reply brief, the absence of
the limiting instruction
created the
yes.
substantial risk.
But when
Okay.
weighing the absence of the limiting instruction, we also consider the volume of bad act evidence that came in. And it was a lot. I mean, RM testified about the 6 charged offenses in 2 incidences. There were 2 incidents, the first the oral rape, and the second was the digital rape. Those 2 incidents testified to in detail comprise basically all of the charged crimes. Now, in addition to that, RM alleged that the sexual assaults occurred 2 to 3 times per week for 4 to 6 years and involved these other victims. So there you have hundreds of bad acts, numerous specific allegations of uncharged sexual activity involving 6 alleged victims. Now, those acts included 6 to 7 allegations of oral rape against RM, 1 specific allegation of oral rape against JM, and 2 specific allegations of indecent assault and battery on JC and EJ. Now, the jury taking that at face value without very necessary limitations by the judge would certainly consider that as propensity evidence against my client. So our argument is that the failure to give the bad act instruction really caused the substantial risk of miscarriage of justice in this case.
Could I ask an unrelated question, just trying not to interrupt the flow of your argument too much? With respect to the open and gross, the Commonwealth argues that the challenge to the sufficiency of the evidence of open and gross is moot, where the indictment was null prost after trial, based on, as I understand it, the statute of limitations concerns. Do you agree that that's moot, or do you disagree?
I agree that it's moot for the purposes of this argument. However, I'm not waiving it because if the charges are reversed, if the convictions are reversed, I would be concerned that the Commonwealth may still be able to bring those if a new trial is ordered, in which case we wouldn't have waived the sufficiency of the evidence argument. So we are noting the sufficiency of the evidence, the insufficiency of the evidence on that charge, and we would rely on that argument if the Commonwealth were to bring that charge back.
And that's the only sufficiency argument that you're making in this appeal in the event we agreed with your position. You're not arguing that there's a double jeopardy problem with any of the other convictions?
No, just that one.
Thank you.
So on the motion for a new trial, the Commonwealth argues that you don't challenge the judge's finding that it was not a newly discovered witness. Do you agree with that?
He was newly discovered in the sense that the Commonwealth tried to contact him, could not contact him, and that's clearly in the record, they made an effort to contact him. They couldn't get his information. And then post-conviction, our investigator was able to locate him through very able footwork and contacted him and spoke to him, and we have the investigator's affidavit. Unfortunately, he didn't follow up with his own affidavit, but I think that was a sufficient showing, at least, to get us an evidentiary hearing and further discovery on that motion. Now, I have very little time left, so I'd just like to make one point. We haven't reached the issue of the motion for new trial, but I just wanted to make the point that we've made a substantial showing on a serious issue, ineffective assistance of counsel. It was an abuse of discretion for the motion judge to deny my client's motions so that some of the questions raised in our brief can be answered. Now, without this information, counsel was not prepared to make a strategic decision on whether to raise this issue or not. So my brother is saying this was a strategic decision by counsel, and the motion judge said counsel made a strategic decision not to impeach RM with evidence of his probation violations, which could be used to show motive to lie. And what I'm saying is this was not just run-of-the-mill impeachment evidence. Burglaries don't show motive to lie. This is not to be taken with his other convictions. This required further investigation by counsel to determine exactly what did he say to the Commonwealth, what did the prosecutors communicate with him about those probation violations when he was coming into Massachusetts and subject to summary arrest. There are no other questions?
Thank you very much.
Thank you.
We'll take a short recess and, oh, I'm so sorry. Commonwealth.
It's quite all right. Thank you very much. May it please the Court, Kenneth Steinfeld for the Commonwealth. I don't have a lot to add substantively to my brief, which lays out at great length all the Commonwealth's arguments, which members of the panel have already demonstrated an understanding, if not an agreement, with. First of all, my brother said several times that the jury was overwhelmed by the bad acts evidence. That is clearly not the case. There was a count of indecent assault and battery on a person aged 14 or over, which the defendant found the defendant not guilty on. That was probably because, based on the dates, the victim was born in
Just a little bit louder.
I'm sorry. Where did you?
That's fine.
Okay. The jury found him not guilty of the one count of indecent 14 or over, presumably because the victim was born in 1991, and the victim testified that the last event occurred while he was in 10th or 11th grade, which was from 2004 to 2006. The victim turned 14 in 2005, so there was not sufficient evidence for the jury to find that he committed a sex crime against the victim when he was 14 or older. That's a very discerning jury. Had they been overwhelmed by all of this bad act evidence, they would have found him guilty on the indecent over as well as the indecent under, as to which there was a lot of evidence.
So what about his argument that, say the jury just doesn't believe the two other young men who came and testified that they weren't abused, and so the jury then is left with, do we believe RM and these 100 other acts? And that therefore tainted the jury verdict.
I don't think that's a taint. I think that's the process that a jury will undergo to determine whether or not the victim's credibility, whom to believe is their province. If they
Right, but let me put it in a sharper way then. Let's assume these other young men did not testify, and we just have this, the RM saying it was me and all these other boys, and the judge does not give the limiting instruction. Then, and the defendant raises that. Where are we then? We reversing at that point?
The defendant objected to it? No, I don't think that the lack of a limiting instruction would be sufficient in that case to overturn it. It, of course, would have been advisable, but if it was not asked for, I'm not sure if you're talking about if he asked for the instruction and not get it, or didn't ask for it and didn't get it.
How would the jury know? If there's no limiting instruction, then there's no guidance as to how they should use it, right?
Well, but that instruction would have said you can only consider it for the purpose of the plan or scheme or operation, not for propensity. That may well have precluded the jury from using it the way that the defendant wanted him to use it, which was to show that that the victim was a liar. It was all favorable to him. The bottom line of this whole case is that it was a totally reasonable strategic decision to have this evidence in. I don't think the instruction would have made all that much of a difference here. And here, I don't think it would have even made a whole lot of sense, because as I said in that footnote, the whole point was these boys said that it didn't happen, and he said that it did. So a limiting instruction as to the bad acts evidence, I just don't see how that would have advanced the defendant's case.
But even if the limiting instruction, I guess what my question is, the limiting instruction would include language saying you may consider only for these purposes, and I understand your argument as to that. But as to the portion of the instruction that presumably would have said, and you may not use it as propensity evidence, why isn't that always going to be valuable to the defense?
It has some value, but in the context of this case and the claims of the defense, I don't think it was necessary. I totally agree that it would have had value, and I would add, when the judge instructed on first complaint, he did give a limiting instruction when the victim testified that he heard about the sexual abuse of other boys. So the jury knew that they were not supposed to use that for propensity purposes. I think that in the context of this case, although I admit it would have been helpful, that it would not have made a difference here. And of course, it was not asked for, and it was consistent with defense counsel's defense of fabrication.
Right, but isn't the defense entitled to use impeachment and, advance their trial strategy, right, by attacking the credibility of these other, I guess in this case the witnesses were testifying consistent with what would be helpful for his defense, but also be entitled to the protections of a limiting instruction?
Well, yes, he was not entitled to it because he did not ask for it.
Well, but the judge
The question was he harmed sufficiently by its absence? Well, the judge,
the judge planned to actually give it. There was a written decision. I don't really know what happened.
But his decision concerns the Commonwealth's motion before the defendant had said anything. Filed the motion, said, we want to put this in with a limiting instruction. Judge says, okay, I agree, that's what I should do. Defense counsel then says, but I want it in anyway. So the Commonwealth said, well, I filed that motion just to get this issue before the court. And so when the judge said that he was going to give the instruction, he was referring to the Commonwealth asking that it come in as bad acts evidence before the defendant said anything about him introducing it. So that sort of mooted the instruction. As soon as the defense said, well, I'm going to ask for this anyway, the instruction was only if the defense counsel did not object to its coming in. But as soon as he did, as I said, the need for it just washed out. And the key for defense counsel was that he had these witnesses who were coming in who were going to say that he lied. I could see that that part of the instruction that Justice Hand has pointed out would have been helpful, but I don't think that the lack of that aspect of it is enough to reverse these convictions. In light of the extensive impeachment evidence that the defense counsel did introduce, he had more impeachment evidence in this case than most defense lawyers do in similar cases of long delayed disclosure child sexual abuse cases.
But here, there were two witnesses who said, no, I wasn't sexually abused, but RM had said there were several other witnesses. So what is
I'm sorry, who said there were several other?
RM had testified there were like 6 or 8 other young people, and then 2 of those came in and said, no, I wasn't abused. So aren't we leaving the jury with some risk of inferring what happened with the other witnesses that didn't testify?
Well, that's a strategic decision made by defense counsel that I don't think is manifestly unreasonable. At trial, the victim testified that there were 5 boys who had also been sexually abused. Those are the 5 that were actually testified to. There's evidence in discovery about others, but those 5. So 2 of those testified, as did a boy named Will, who had, and the victim had said prior to trial that had been one of the boys. The parties and the court sort of acted like the victim had testified that had been one of those boys. So the defense counsel argued that, in fact, 3 boys had testified that there had been no sexual abuse. And the Commonwealth, in its closing argument, gave a very good distillation of why young men may not want to come and testify that they were sexually abused all those years ago. And I think that that would have explained to the jury very, very well, based on their reasoning and their understanding of child sexual abuse, why all of the boys were not in court. It's sort of like a missing witness kind of situation, but there's no claim before us about that. The defense counsel made the strategic decision that having 3 boys testify would be a very strong defense, though there were still 2 who did not. But as I said, there's a lot of explanations for why those boys might not have shown up.
I mean, but that is part of the concern, that the Commonwealth did do a good job negating those witnesses who said they weren't abused, and then that leaves the state of the evidence as RM basically saying all these other boys were abused. This was a, overwhelming situation, and that the limiting instruction was necessary.
Well, as I've said, I don't think that it was necessary or that it would have helped. I don't really have anything further to add to that other
Well,
than...
but that's the question I'm asking. If the jury believed what the Commonwealth was arguing, that in fact, even though these 2 or 3 witnesses denied they were sexually abused, the jury believes the Commonwealth, that there are reasons why young men or young people would want to deny that they were abused.
Sure.
Then you're left with so they're taken out of the equation, and then we're left with the state of the evidence of RM saying that all these other boys were in fact sexually abused. And then there's no limiting instruction about bad acts, right? That's the problem here.
Well, I don't see it as a problem in light of the strategy, the reasonable strategy of defense counsel to focus on the fact that he had 3 boys who came in and said that it didn't happen. The instruction, I disagree respectfully.
I guess
that it would have
let's
had any
ask
effect
it
on the jury at all.
a different way. Would there have been a downside to the defendant in having the limiting instruction provided?
No, not to the portion of it that said you can't consider it for propensity or to determine that he's a bad person. No, there's no downside to it, but just the fact that there was no downside does not make it either ineffective assistance or cause a substantial risk of a miscarriage of justice for it not to have happened. So I'm not going to deny the efficacy of that portion of the instruction, but I think it would have played a minimal, if any, role in this case and not grounds for reversal in light of the testimony from Robert. And I'd like to add to that the defense counsel said in his affidavit that he thought that the victim was a very, very sympathetic and compelling witness, which he also knew from discovery. And during discovery, he had received a copy of the SANE interview. So he knew that witness and how he expected to testify. So his decisions about what to do at trial were based on that, and they were certainly reasonable in light of his assessment of the credibility and the sympathetic nature of the victim.
The Commonwealth asked for an instruction, limiting instruction, right?
When it asked for the evidence to be admitted just as bad acts evidence, it did not ask for the instruction after defense counsel said, well, I want it in anyway. So
the request was at the time it was moving to admit the evidence?
Yes.
It was not at the time?
That's correct.
Okay.
It was when I'm not sure that's clear in our papers, but yes, when the Commonwealth filed the motion, it said with the instruction, because they did not then know what defense counsel's position was going to be. As soon as they learned that, then the Commonwealth didn't need the instruction, and I don't think that the defendant needed it either, because it was superfluous, although not, as I said, necessarily unhelpful.
So turning to the open and gross lewdness, is there a representation from the Commonwealth that if we do reverse, that the Commonwealth will not pursue the...
Absolutely, yes.
Okay.
Yes, it is barred by the statute of limitations, a no process entered. We're not going to stand up in the Superior Court and say we will go no further and then change our minds later, and we are barred as a matter of law from proceeding. So I can certainly make that representation to this court.
Do you think we are obligated to reach the issue anyway because of the stigma that attaches to the conviction?
Well, but no, because there is no conviction. It was no process and it was dismissed. So there's no stigma and there's no conviction. And as I say under the statute, there's no judgment for this court to, I could see that, so in fact, if the Commonwealth were to decide to recharge him in the future, then he could file a motion to dismiss, saying that there was insufficient evidence at the first case. And so he could fight it that way if we tried to. But as I'm saying now, and as I said in my brief, we do not intend ever to charge him, and we can't charge him with open and gross lewdness based on conduct during that 6-year period.
So on the motion for a new trial, the defendant argues that the victim likely discussed his probationary status with members of the prosecution team in January and February of 2013, and that this was not disclosed to the defendant. What do you say to that?
Well, likely, but he doesn't have evidence that it was. I'm not sure what I mean, we turned over all of the memos and the notes of their interactions. It is merely speculating that all these things might have happened. It's one list of might have after another. Might have known, might have received lenience, might have this, the court might have known that, the Commonwealth might have known this. The only evidence was that the prosecution team sought to help him by telling the defense counsel, by confirming that he was a survivor of childhood sexual assault, and to see whether they could help him get into a program. They ultimately did not help him get into a program. He independently was admitted to the BOAT program, and there's been, as I said, no showing that he would not have been admitted to the BOAT program had he not also been a victim of childhood sexual abuse. So I think that claim is wholly speculative, and it just lacks evidence in the record that he got any benefit from being a childhood sex abuser in his other cases.
So you had argued that the defendant did not challenge the judge's finding that Ed was not a newly discovered witness. Now, you've heard your learned opponent argue that the Commonwealth had not been able to contact post or pre-trial. What do you say to that?
Well, they had a duty. They found him after trial.
Who
the
found
defense
him?
Investigator said that before trial, they did not try to find him.
Okay.
That's in his affidavit. So right there, that's all I said in my opposition to the motion for the trial. We did not try to find him. And I also think that the claim is waived because he doesn't even address it on appeal. But even if he did, the record shows clearly that he was known based on discovery to defense counsel, and they simply made no effort to contact him. He does not say that it was ineffective for him not to, but he can't now claim that it's newly discovered when he had the boy's name beforehand and made no effort to contact him.
Okay.
If the members of the court have no further questions, I'd be happy to rest on my brief.
Thank you.
Thank you.
Now we will reconstitute the panel.
All rise, please.